Thanks very much, Gavin. The latter part of that introduction was entirely accurate. The early part, I think, was affected by a bit of hyperbole. I wanted to thank the Society very much for the invitation to speak this morning. To all people who are here today who are residents of Victoria, welcome to the sunny Gold Coast. And on this rainy, overcast Gold Coast morning, I can feel the general excitement in the room following Tom's topic at the prospect of you all here having to listen to a State Supreme Court judge well and truly stepping outside of his lane to touch upon a topic which is firmly entrenched in admin law to a large extent. I'm very conscious that the room has this morning a number of esteemed judges and academics and lawyers who lead the area in administrative law, and to all those persons I sincerely apologise for the next 25 minutes. The topic is actually, Xavier was asking me to provide a topic and I provided a topic. It's probably not perfectly worded, but the reasons why I thought the topic was of some general interest, certainly to me and I hope to some of the people this morning, is this. The High Court has recently delivered a judgment of the court on jurisdictional error and materiality, which is going to be of great assistance to the profession in approaching the task of identifying jurisdictional error, and I'll touch upon that case during the course of the speech. The supervisory jurisdiction of the Superior Court is rarely exercised. I came across it in a quite different context in the course of a criminal proceeding which was before the District Court, where a question of law had been determined at a pre-trial hearing, and an application was made to the Supreme Court in its supervisory jurisdiction in circumstances where there was no statutory right of appeal until after the criminal trial had been heard and determined. When I say I came across it, I had to consider the supervisory jurisdiction in that context. I think the starting point is that the supervisory jurisdiction of a Superior Court is available in the context of jurisdictional error, and one potentially difficult area of jurisdictional error, which I think is very relevant to our community, is when will a breach of procedural fairness constitute jurisdictional error? And so it may well be that the supervisory jurisdiction of a Superior Court has very limited application in practicality to a situation where there has been a breach of procedural fairness constituting jurisdictional error. But at the very least, what I hope to achieve this morning is to make people aware of the importance of the supervisory jurisdiction in terms of what it was intended to achieve, and to touch upon some of the more contemporary jurisprudence dealing with what is jurisdictional error and when will a breach of procedural fairness constitute such an error. So at the time of federation, each of the Supreme Courts referred to in Section 73 of the Constitution possessed the power of supervising the exercise of jurisdiction by inferior courts and tribunals. The supervisory power was devolved upon those courts as an incidence of jurisdiction inherited from the Court of Queen's Bench in the exercise of the royal prerogative of justice. In particular, each of those courts had a general power to issue a writ of certiorari to any inferior court or tribunal. In Queensland, Section 4, subsection 2 of the Judicial Review Act 1991 preserves the Supreme Court's jurisdiction to grant any relief or remedy by way of a writ of mandamus, prohibition or certiorari, although the power to issue the prerogative writs themselves has been abolished. In Kirk and the Industrial Court of New South Wales, the joint judgment made this observation: the supervisory jurisdiction of the Supreme Courts were at federation and remain the mechanism for the determination and enforcement of the limits on the exercise of state executive and judicial power by persons and bodies other than the Supreme Court. That supervisory role of the Supreme Courts, exercised through the grant of prohibition, certiorari and mandamus, was and is the defining characteristics of those courts. The principal functions of one of the prerogative writs, certiorari, was to enable the court to identify excesses of jurisdiction and examine for errors of law. The two principal grounds for relief in the nature of certiorari are ordinarily described as jurisdictional error and error of law on the face of the record. Two observations can be made about those principal grounds. Firstly, the concepts of jurisdictional error and the record have historically each suffered from a degree of uncertainty as to their meaning. That was specifically acknowledged by the joint judgment in Kirk. Secondly, it may be accepted that although there are two principal grounds for relief in the nature of certiorari, there is no single principle which underpins or explains the rationale for each of those grounds. The grant of certiorari sought to keep an inferior tribunal or court within its jurisdiction by requiring that court to observe the law, that is, the law is found to be the law by the superior court, but on the other hand, there has always been some expediency or perceived expediency in providing an inferior decision with some degree of finality. The latter position is often encapsulated by the thinking to the effect that an inferior court or tribunal should have some jurisdiction to go wrong. In the Queen and the Governor of Brixton Prison, Lord Reid said words to the effect that a magistrate did not destroy his jurisdiction by reaching a wrong decision. If he had jurisdiction to go right, he had jurisdiction to go wrong. In Kirk, two of the intervening states, Victoria and South Australia, had made a submission referencing statutory privative provisions enacted by colonial legislatures which had sought to cut down the availability of the grant of certiorari. And in response to that submission, the joint judgment referenced an earlier decision of the Privy Council in Colonial Bank of Australasia and Willan as authority for the proposition that at the time of Federation, there was an accepted doctrine that the jurisdiction of the colonial Supreme Courts to grant certiorari for jurisdictional error was not to be denied by a statutory privative provision. That is, a state legislature could not deprive the state superior court of a power to remedy jurisdictional error. Following Kirk, we can say with some confidence that the distinction between jurisdictional error and error on the face of the record is an important distinction, at least because it marks a relevant limitation on a state's legislative power. The existence of jurisdictional error may be regarded as an established pathway to the Supreme Court's supervisory powers. However, whilst it's very easy to state the proposition in that way and to use the label of jurisdictional error, the identification of jurisdictional error often demands a rigorous analysis. During the oral argument in Kirk, Justice Gummo at one point referenced what he referred to as the unfathomable distinction between jurisdictional and non-jurisdictional error. Justice Leeming, writing extrajudicially in 2014, compared the concept of jurisdictional error to a riddle. The joint judgment of Chief Justice Kiefel and Justices Gageler and Keane in Hussain and the Minister for Immigration remarked that jurisdictional error is an expression not simply of the existence of an error, but of the gravity of that error. And their honours later spoke in terms of a decision being of a magnitude which has resulted in taking the decision outside the jurisdiction conferred by the statute. Their honours observed that the distinction between jurisdictional errors and non-jurisdictional errors is ultimately a distinction between errors that are authorised and errors that are not, between acts that are unauthorised by law and acts that are authorised. In the last few months, in LPDT and the Minister for Immigration, Citizenship, Migrant Services and Multicultural Affairs, the High Court delivered judgment in an appeal which concerned jurisdictional error and the requirement of materiality. From that recent decision in LPDT, we can draw considerable assistance in our approach to the identification of jurisdictional error. I will start with some initial propositions from that authority. First, jurisdictional error can refer to a breach of an express or implied condition of a statutory conferral of decision-making authority, which results in a decision made in the purported exercise of that authority lacking the legal force attributed to exercise of that authority by the statute. Secondly, a decision affected by jurisdictional error is in law no decision at all, and in that sense is void. And thirdly, the categories of jurisdictional error are not closed. Beyond those initial propositions, there are some parts of the High Court's judgment which I wish to note in some detail. At paragraph 4, the Court said, by way of quote, "A statute which contains an express or implied condition of a conferral of decision-making authority is not always to be interpreted as denying legal force and effect to every decision that might be made in breach of that condition. Only by construing the statute so as to understand the limits of the statutory conferral of decision-making authority is it possible to determine first whether an error has occurred, that is, whether there has been a breach of an express or implied condition of the statutory conferral of decision-making authority, and second, whether any such error is jurisdictional, that is, whether the error has resulted in the decision made lacking legal force." The Court then said determining whether an error exists as well as whether it is jurisdictional starts with an analysis of the nature of the error alleged in the statutory context within which the decision has been made. Given the broad range of decisions in which errors might be made, the large variety of statutory schemes in which those decisions might be made, and the range of circumstances which may attend the making of any particular decision, it is impossible to define a rigid classification of the errors that constitute jurisdictional errors. There are no bright lines to be drawn. The nature of the error has to be worked out in each case concerning a specific decision under a specific statute. The High Court did identify 2 examples of cases where jurisdictional error can be established without inquiring into whether the error was material to the decision that was made in fact. The first example is where an error is established and is regarded as jurisdictional irrespective of any effect that the error might or might not have had on the decision that was in fact made, and an example of such an error is apprehended or actual bias. A second example is where the potential for an effect on the decision is inherent in the nature of the error, such as where there is unreasonableness in the final result. However, most cases of error will only be jurisdictional if the error was material to the decision that was made in fact. In that sense, there is a realistic possibility that the decision that was made in fact could have been different if the error had not occurred. Having noted that jurisdictional error is an entree to the supervisory jurisdiction of the superior courts, I would like to consider one possible jurisdictional error which might engage the supervisory jurisdiction, namely a circumstance where there has been a failure to observe some applicable requirement of procedural fairness. I use the word contentious in the title to this speech because whilst it may be accepted that a relevant gateway to the supervisory jurisdiction of a superior court is the concept of jurisdictional error, the identification of jurisdictional error in the particular circumstances of an error involving a breach of procedural fairness can be difficult and contentious. And it is also difficult to conceive of particular circumstances where such an error would probably engage the supervisory jurisdiction as distinct from being dealt with under judicial review. I'd like to introduce the concept of procedural fairness as a fluid concept, and by fluid I mean that it is a concept that ultimately can be defined and circumscribed by the legislature. The expression natural justice, the source from which our modern concept of procedural fairness flows, has long been described in many authorities as lacking in precision. In Norwest Holst Limited and Secretary of State for Trade, Lord Justice Omrod observed that the word natural added nothing whatsoever to the concept of justice, except, as his lordship said, perhaps a hint of nostalgia. And the authors of DeSmith's Judicial Review have quipped that no one possessed of the slightest acquaintance with the medieval English legal system would ever suggest that the elements of judicial procedure, which now are regarded as the hallmark of a civilised society, were ever generally enforced or even generally regarded as proper. As an aside, in 1902, Sir Samuel Griffith sat on the full court of the Queensland Supreme Court in a criminal appeal on a question of law concerned with whether the Crown could reply in circumstances where the accused had been self-represented and had not called evidence but had addressed the jury. In the course of considering that question, Sir Samuel Griffith, remembering that this was in 1902, remarked that until apparently recently, prisoners were not allowed to be defended by counsel at all. I found that quite startling that as recently as the turn of the last century that a prisoner in Queensland would not be allowed to be represented by counsel. Since the time of the ancient Greeks, justice was administered by reference to a precept that no person was to be judged unheard, and the Greeks regarded that principle as a practical aid to good decision-making rather than as an abstract principle of justice. From both a practical and a moral perspective, the quality of a hearing given to a person and that person's ability to participate in and contribute to that hearing will usually be regarded as vitally important. It has been variously suggested that phrases which express the same fundamental idea as natural justice might include phrases such as substantial justice, fundamental justice, rational justice, fair play in action, and fairness writ large and juridically. Those phrases are, of course, of very limited utility, but they tend to emphasise that there is a close relationship between common law and moral principles inherent in our contemporary understanding of natural justice. In the purest case of a breach of procedural fairness, we might say that something has gone wrong with the procedure which offends rational logic and common sense. There can perhaps be some intrusion of morality into that consideration. Today, most legal practitioners would confidently identify two classical elements of a fair hearing without more. Firstly, that the party should be given a proper opportunity to be heard, and that the person adjudicating should be disinterested and unbiased. The High Court accepts that the statutory context of any decision is a crucial source to influence and determine the requirements of procedural fairness, and it may also be accepted as a fundamental principle that if drafted with sufficient clarity, statutes can and do displace common law fair hearing requirements. Can I give one example of that scenario? In National Companies and Securities Commission and News Corporation Limited, the High Court considered a statutory power conferred upon the National Companies and Securities Commission to hold public or private hearings for the purpose of performing any of its functions or exercising any of its powers, which proceedings were to be conducted with as little formality and technicality and with as much expedition as the requirements of any relevant statute and a proper consideration of the matters before the Commission permitted. In the context of that hearing, the Commission was not bound by the rules of evidence, but was required to observe the rules of natural justice. The Commission was entitled to decide who might attend and who might intervene at the hearing. And in the context of considering that statutory provision, Chief Justice Gibbs said, "Let it be assumed that as a result of the hearing, the reputation of the respondents may in some way be affected. The question would then be, what natural justice requires when a hearing, publicly announced but held in private, is held only for the purpose of investigation, the hearing being one in the course of which no issue can be determined, and as a result of which no right, interest or legitimate expectation can be affected, although the reputation of the respondents may be damaged. That question has to be answered in the light of a statutory framework which expressly recognises the need for expedition and gives the Commission power to decide who may attend and who may intervene at the hearing. If the Commission were to accord to all the persons whose reputation might possibly be affected by the hearing a right to cross-examine and call evidence as though they were in a court of law, the hearing might become so protracted as to render it practically futile. In these circumstances, I find it quite impossible to say that the rules of natural justice require the Commission to proceed as though it were conducting a trial. It seems to me in no way unfair that at a hearing of the kind which I've described, the respondents should not be entitled to cross-examine such witnesses as the Commission may call or to call evidence of their own." That was the Chief Justice considering a very specific statutory context and a very specific type of hearing contemplated by the statute. In our community, we've recently had a very high-profile case, not involving a tribunal, not involving a statute, but where two high-profile AFL coaches were the subject of an investigation conducted in private by their clubs, as a result of which their reputation was significantly damaged, and in respect of an investigation which they did not know was occurring, which they were not apprised of the charges and were not apprised of the evidence sought against, to be adduced against them at that investigation. Without the benefit of that hearing occurring in a statutory context as outlined by Chief Justice Gibbs, most people in the community, I think, were affronted by the notion as to whether fair and due process were being afforded to those two individuals in that informal context. But I mention the decision and the remarks of Chief Justice Gibbs only to emphasise that in an appropriate context, a statute may provide for a framework or a procedure for decision-making which is countenanced by the legislature and produces what is regarded and can be regarded as a matter of law as a fair process. In the recent case of LPDT, the High Court considered it desirable to provide practical guidance to the profession in terms with which all members of the court agreed to assist with the identification and application of the principles governing the assessment of materiality in the context of jurisdictional error. The relevant passages of the High Court's judgment appear at paragraphs 9 to 16, and for present purposes I will simply identify some aspects of those paragraphs. Firstly, where in judicial review a decision is said to be affected by jurisdictional error constituted by a breach of an express or implied condition of a conferral of decision-making authority by a statute which incorporates a requirement of materiality, two questions will arise. Firstly, has an error occurred, and if so, was that error material? The Court has told us that this inquiry is wholly backward-looking and that both questions are to be answered by reference to the decision that was made and, depending on the nature of the error, how the decision was made. The applicant for judicial review will always bear the onus on these issues. Thirdly, where the jurisdictional error is concerned with the process of the decision-making, such as a denial of procedural fairness, what must be proved will depend upon the precise error alleged to have occurred in the decision-making process, having regard to any relevant statutory provisions within the applicable legislative framework. Fourthly, the applicant must satisfy the Court that the alleged error in fact occurred, and in the usual type of case we have been considering, that is, whether the error is material, will be determined by inferences drawn from the evidence. In those usual types of cases, the question, importantly, is this: whether the decision that was in fact made could, not would, realistically have been different had there been no error. What must be shown to demonstrate that an established error meets the threshold of materiality will depend upon the error itself. In some cases, it will be sufficient to show that there has been an error and that the outcome is consistent with the error having affected the decision. But where the error is the denial of procedural fairness arising from a failure to put the applicant on notice of a fact or issue, the Court may readily be able to infer that if fairly put on notice, the applicant might have addressed the fact or issue by further evidence or submissions, and the decision maker would have approached the further evidence or submissions with an open mind. In those cases, the High Court has emphasised and observed that it is, quote, no easy task, end quote, for the Court of Review to be satisfied that the loss of such an opportunity did not deprive the person of the possibility of a successful outcome. Elsewhere in the judgment, the Court had cited its decision in Nathanson and Minister for Home Affairs and emphasised that although the applicant must satisfy the Court that the threshold of materiality is met, in order to establish that the error is jurisdictional, meeting that threshold is not demanding or onerous. Could I make some observations about procedural fairness and jurisdictional error. Kirk, as we have seen, makes plain that, quote, legislation which would take from a state Supreme Court power to grant relief on account of jurisdictional error is beyond state legislative power. Justice Leeming, writing extrajudicially, has made a point which can be stated in the following terms. In the specific context of jurisdictional error and procedural fairness, there is an implied limitation on legislative power to deny jurisdiction to review for failure to accord procedural fairness. Yet there is a very clear legislative power to subtract from, dilute or displace the content of the obligation to accord procedural fairness in the first place. Standing back from that proposition, it seems somewhat anomalous, and Justice Leeming illustrates his point by reference to a case in which His Honour appeared as counsel in Commissioner of Police New South Wales and Grey. That case concerned statutory provisions dealing with the grant of security licences under the Security Industry Act of 1999. Section 15, subsection 6 of that Act provided a restriction on the grant of a licence directed to whether an applicant was a fit and proper person to hold the licence. In that inquiry, the Commissioner might have regard to any criminal intelligence report or other criminal information held in relation to the applicant that was relevant to the licence, caused the Commissioner to conclude that improper conduct was likely to occur if the applicant were granted the licence, or caused the Commissioner not to have confidence that improper conduct would not occur if the applicant were granted the licence. Pursuant to Section 29 of that Act, an unsuccessful applicant for a licence might apply to the Administrative Decisions Tribunal to review the Commissioner's refusal to grant the licence. But Section 29(3) then provided that the Tribunal, in determining the application for review, was relevantly, firstly, to ensure that it did not, in the reasons for its decision or otherwise, disclose the existence or content of any criminal intelligence report or other criminal information referred to in Section 15(6) without the approval of the Commissioner. And secondly, in order to prevent the disclosure of any such report or information, is to receive evidence and hear argument in the absence of the public, in the absence of the applicant for review and the applicant's representative and any other interested party, unless the Commissioner approved otherwise. In the New South Wales Court of Appeal, Justice McColl, with whom Justices Giles and Tobias agreed, reasoned that the statutory scheme I've just outlined ensured that the existence of confidential materials came to the notice of the Tribunal, but gave the Commissioner the opportunity to make a non-disclosure claim in the event that claim was made. The section established the procedure by which the claim was to be determined by the Tribunal. Section 29(3) was found to operate to disentitle an applicant to knowledge of both the existence and content of any material used against him for the purpose of the external review. The applicant was thus, by reason of that provision, denied access to materials which would otherwise have been made available to him pursuant to other sections of that Act, or by the application of principles of natural justice and procedural fairness as commonly understood. In that particular statutory scheme, the Legislature had exercised its power to significantly dilute a requirement of generally understood principles of natural justice. And in that particular case, there would have been jurisdictional error had the Tribunal proceeded on the basis that it was bound to afford basic natural justice to the applicant. Indeed, in that scenario, potentially, the supervisory jurisdiction would have been available by granting relief akin to prohibition, restraining the Tribunal from disclosing information to the applicant. In LAPD, the High Court emphasised that a court called upon to determine whether the threshold of materiality has been met must be careful not to assume the function of the decision maker. The High Court emphasised, in a cautionary note to the profession, the point at which the line between judicial review and merits review is crossed may not always be clear, but the line must be maintained. That line can be particularly difficult to ascertain in circumstances of breaches of procedural fairness where, for example, a court is asked to draw inferences from the evidence to identify and establish the actual error that has occurred. However, what I draw from the recent statements from the High Court in LAPD and in Nathanson directed to the threshold of materiality, notably the statements in Nathanson which make clear that meeting the threshold is not demanding or onerous, is a strong basis for a court to avoid embarking upon something in the nature of a quasi-merits review under the guise of establishing jurisdictional error. Commentators often refer to the famous statement of Sir Frederick Jordan that there are mistakes and then there are mistakes. Ultimately, with jurisdictional error, we are concerned to identify an excess of power. In the context of breaches of procedural fairness, there is a particular need for caution to only identify breaches that go beyond power. One pertinent point, or noteworthy point perhaps, is that with procedural fairness in the conduct of a hearing, it is often not possible to discern the material error until after the hearing has occurred and a decision has been made. Unlike some other types of jurisdictional error with breaches of procedural fairness in the course of a hearing, the existence and gravity of the error may only be discoverable from a careful consideration after the completion of an entire process. Finally, it's worth recalling that in Kirk, one of the jurisdictional errors involved a breach of Section 17(2) of the Evidence Act, which provided that a defendant was not competent to give evidence for the prosecution. The prosecution, in that case, had called Mr. Kirk as a witness. The identified jurisdictional error involved, in that sense, an application of the rules of evidence. And stating it in those terms, it may seem unusual that a misapplication of rules of evidence could give rise to jurisdictional error. In Kirk, Justice Hayden made these remarks, which I would just like to quote. The law required that hearing to be conducted in accordance with the rules of evidence. His Honour then postulated this question: will every error in applying those of the numerous rules of evidence which cannot be dispensed with pursuant to the fairly strict requirements of Section 190 or bypassed by agreeing facts pursuant to Section 191 or outflanked by making admissions be a jurisdictional error? That question should be reserved for consideration on a case-to-case basis. It is possible that there may be instances of failure to comply with the rules of evidence which are of insufficient significance to cause the court making them to move outside of jurisdiction. It is also possible that even insignificant failures would be jurisdictional errors, but not jurisdictional errors of a type justifying the exercise of an appellate court's discretion in favour of the grant of relief. Justice Hayden observed in that case in Kirk that the trial judge had jurisdiction to, quote, decide whether to find the appellants after a trial conducted in accordance with the rules of evidence. He did not have jurisdiction to decide whether to find the appellants after a trial which was not conducted in accordance with the rules of evidence, end quote. But having reached that conclusion, Justice Hayden noted that it was wrong to have characterised the treatment of Mr. Kirk, that is, the requirement for him to give evidence, as a mere technicality. His Honour referred to that rule that had been breached in that case as, quote, absolutely fundamental and as, quote, underpinning the whole accusatorial and adversarial system of criminal trial in New South Wales. The other error in Kirk involved a failure to plead conduct amounting to a relevant offence. That involved the industrial court misapprehending a limit of its function and powers by making orders convicting and sentencing Mr. Kirk and his company where no particular act or omission or set of acts or omissions had been identified at any point in the proceedings up to and including the passing of sentence. The failure to identify the particular act or omission followed from the industrial court's misconstruction of Section 15 of the relevant Act. The High Court regarded that particular error, the failure to give that particularity, as a grave breach of procedure which led to obvious injustice and as an error outside of jurisdiction. Can I make this final observation about Kirk? Although we've seen many solemn statements in the cases about the need to avoid merits review, at least in the reasons of Justice Hayden, I think we can say that the merits of the case in Kirk did not go entirely unnoticed by His Honour, and that view resonates in the following remarks from Justice Hayden in Kirk. The proceeding should never have been instituted. It was absurd to have prosecuted the owner of a farm and its principal on the ground that the principal had failed properly to ensure the health, safety and welfare of his manager, who was a man of optimum skill and experience much greater than his own, and a man whose conduct in driving straight down the side of a hill instead of on a formed and safe road was inexplicably reckless. Ultimately, in discerning jurisdictional error, courts inevitably are required to make a qualitative judgment informed by what Parliament is likely to have intended. What we see in Kirk, by way of the example I've used in a procedural and rules of evidence context, are examples of jurisdictional error of a required magnitude or sufficient gravity to indicate that whatever decision was reached was not a decision within power. The High Court's recent decision in LAPD provides us all with a very clear roadmap for undertaking the task of identifying jurisdictional error and the materiality of errors, particularly in the difficult context of breaches of procedural fairness. Thank you.